You did not complete the PHP. It says right here, you did not, you did not complete it. It says it right there, and then it says verify, which means that they called the coach, they called Izzy's house, and they verified that you did not successfully complete it. Walking out the front door when you have had enough is not completion. I don't see why there's this breakdown in communication with you and your wife. I don't understand, because you and your wife are on a course of destruction, and I'm trying to help you with it. The first thing that you need to do is be honest with yourself, and be honest, certainly be honest with me, and don't tell me that you're the kind of person that doesn't lie, because I think you're smart enough that. Versus William Harrison. Mr. Harrison is before the court with his counsel, Mr. Moss. Ms. Tranter, on behalf of the state of Ohio. Mr. Harrison, your attorney had filed a motion for intervention in lieu of conviction. So in a moment you'll be asked to change your plea to all 3 counts of the indictment. The court accepts your plea but does not make a finding of guilt. Instead, I'll hold your plea in abeyance or set it aside and require you to complete a plan of intervention. If you successfully complete the plan of intervention, then the prosecution of the case will end with no finding of guilt, and I will dismiss these charges against you. Do you understand that?
Yes, sir.
How old are you?
33.
I'm sorry?
33.
How far did you go in school?
The 7th grade.
Can you read and write?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
Document says you're entering a plea of guilty to 1 count of aggravated possession of drugs, a felony of the 5th degree. That carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. The 2nd count is also a count of aggravated possession of drugs, a felony of the 5th degree. That also carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. Neither of these carry mandatory prison sentences. The 3rd count is one of possession of drug paraphernalia, a misdemeanor of the 4th degree, and that carries a maximum penalty of 30 days in the Warren County Jail and a $250 fine.
Your Honor, in addition to the facts alleged in the indictment, this occurred on April the 4th, 2026, Warren County, State of Ohio. Defendant was found to be in possession of 0.03 grams of methamphetamine, a Schedule II substance. Also found to be in possession of hydrocodone, a Schedule II substance, in an amount of 0.44 grams, and also in possession of drug paraphernalia.
Mr. Moss, anything on those facts?
No, Your Honor.
Mr. Harrison, did you hear the statement that was read?
Yes, sir. Yes, sir.
Do you admit that what she stated is true?
Yes, sir.
And again, you understand all the rights you're giving up when you enter a plea of guilty?
Yes, sir.
What's your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights. The court accepts your plea. Mr. Harrison, I'm going to grant your motion for intervention in lieu of conviction and order these proceedings stayed pending the completion of the terms of that supervision. So you will be on aisle C for up to 3 years, subject to the supervision of the Warren County Probation Department. You're ordered to refrain from use of any drugs or alcohol, and that includes marijuana or THC in any form. Do you understand?
Yes, sir.
All right, let's talk about what's been going on since I let you out of jail. Now, I'm going to ask you some questions, and you're going to answer them truthfully for me right now.
Yes, sir.
2 days ago, I had a woman, and I find out she lied to me. So she's sitting in our county jail right now because I have to change my orders, but her attorney had already left. So don't make that mistake and lie to me right now.
Judge, can I bring something to the court's attention?
Yeah.
It's actually his co-defendant.
That was my wife.
Ms. Small is his co-defendant.
So have you had contact with her?
Yeah. When we left the one.
This is a problem right off the bat. I'm telling you. She's in jail, so you know that, and she's in jail. Okay, I'm going to ask you some questions. True or false? I let you out of jail. Community Corrections could not verify a residence for you, so I permitted you to go to the coach. Correct? Yes or no?
Yes, sir.
You're not at the coach, are you?
No, sir.
Where are you?
I got the paperwork.
Where are you? Listen to my question, and you need to answer my question very directly and truthfully. Where are you?
3260 Wayne Avenue, Dayton.
Whose house is that?
It's a sober living.
Are you telling me what's the name of the facility?
That's what I got the paper.
Go get it.
And Anthem's paying for it? I don't know, Your Honor.
What's the name of the agency?
It starts with a C. I
It's
can't
not
remember.
on
It's a longer name. But I am in there. It's a sober living because when we did what we did, it wasn't working.
Wait a minute. When we did what we did, who's we?
Me and her, we left.
You and your wife.
The couples rehab, and it wasn't working. So
Why do you mean not working?
that we still do group and everything, but it just.
Who says it wasn't working?
I did.
Yeah, okay. Here's problem number one. When I give you an order, you follow my order. You don't just go do what you want to do. Are we clear on that?
Yes, sir.
All right, so moving forward, when I place you in a facility, you don't get to just choose that you're going to leave. Either you stay there, or you're going to go into custody, because you don't just get. I don't like these people. I'm going to go do something else. Nope, it doesn't work that way. Yeah, this is a problem now that you two are related and you both did the exact same thing, right?
Yes, sir.
She was at Izzy's house. Isn't that right?
That's exactly right.
Is that where you were at?
Yes, sir.
Is that a branch of the coach?
No, Your Honor.
How'd you end up at Izzy's house?
I asked my probation officer if I could.
Who was that?
Officer Small. And he said yeah, because it was closer to family. I'm fighting a CPS case too. And not having a ride at the time, because the coach wasn't going to keep taking me back and forth to see my kids, bring me here to see them. So I was trying to do that to get a job and everything, and I ended up getting a job and working. Like, I'm working on getting a place here in Warren County with Family Promise and everything. So like I've been trying, but I apologize. I shouldn't have moved.
Did you state of Georgia?
No, sir.
Did you go somewhere for a funeral?
No, sir. I didn't go.
He called me over the 4th of July weekend and told me there had been an accident, and he was asking me if he could go. Apparently he didn't go.
Well, again, he asked Community Corrections are you on a monitor still?
Yes, sir.
He asked Community Corrections if he could go, but never provided specific information about the details of the funeral. So there was never any. When he asked for specific details, none were given.
When I got the paper, it was too late. Like, it was on a Friday, and it was like 4:30. So.
Avenue address. Is that where this facility is, or is that your address?
That's the sober living house. The like 4 minutes up the road is where we go to group. So we do groups like 6 days a week, from 9 to 11:30.
But what is recommended is PHP.
Yes, Your Honor, that is what the coach recommended on his initial assessment that he completed through us. And he was at DeCoach and then went to Izzy's house, and then after that is when he left and went back to Miss Small's house and is now in Communicare.
Did he complete PHP?
Not to my knowledge, no.
Yes, Your Honor, I did.
I'm sorry?
Yes, I did. I was in,
Be careful, because I think there's the same words that came out of your wife's mouth on yesterday, and I found out later that she did not successfully complete it. There's a difference between successfully completing something and being terminated by the agency or walking away. There's a difference. So be careful what you're telling to me, because she's in jail right now.
No, I understand. Like, I'm not going to lie. Like, I'm not that type of person. I know that.
Yeah, she said the same thing.
I know that I messed up, but you could ask my PO. Like, I'm doing really good.
Well, it says here.
At
Here's
this
what it says here.
stage, the hearing reaches its most significant turning point. The issue is no longer simply whether Mr. Harrison struggled with addiction. It's whether he complied with the court's specific treatment orders. Legally, that's an important distinction. Intervention in lieu of conviction is built on following structured rehabilitation requirements, and the judge repeatedly emphasizes that defendants cannot substitute their own choices for court-approved treatment. The verified reports indicating the programs were not completed directly affect the court's confidence in Harrison's credibility. Notice how the judge keeps returning to documented verification instead of personal explanations. That's often how courts resolve disputes over compliance. What do you think? Should a judge rely primarily on official treatment records, or should a defendant explanation receive more weight when circumstances become complicated? Watch how the judge responds, because the next decision will determine whether this opportunity continues, or whether the situation moves much closer to custody.
That's how they explained it to us. So I try to set something up to get back in the program, and that's why you see it says yesterday. That's when they was doing my intake and everything. Like I'm not trying to lie. I apologize. I know I did wrong.
Listen, you're not in jail right now because I let you go to the coach. You leave the coach and then you go to Izzy's house. You leave Izzy's house and you go where you're living somewhere else up in Dayton that none of us have ever heard of. And on top of all that, this isn't even the level of care that you were ordered to complete, that I said you were to complete. That was a condition of your bond, right?
Yes, sir.
I mean, you basically used that as a device to get out of jail, saying, I want treatment, I'm gonna go do to coach. So I let you go to the coach, and then you leave, right? That's what's happened here.
I see that.
All right.
Like I do. Like I have been doing really good. You can see it when I was at the coach. I didn't miss a group. I went to every meeting.
Mr. Harrison, understand that you did not complete the program. I mean, you were in jail, as I recall. You tested positive for fentanyl, right? This is after you were indicted. You test positive at your arraignment, I believe, for fentanyl, correct? You have a serious drug problem, and you think that you're going to pick, you and your wife think that you're going to pick and choose how you're going to handle this. You're not. I'm going to give you intervention in lieu of conviction, but you're going to do things the way that it's being recommended to me. These people that are making these recommendations, they're experts. So you are going to complete the PHP at this point in time. It's not going to be, they'll cover all of these recommendations, individual, family, couples. Again, the family and couples therapy can wait. You need to work on yourself first.
Yes, sir.
Are you on medications right now?
They like heart medicine, nothing.
Are you on any mental health medications?
No, sir.
I believe he's on Suboxone.
Suboxone.
You're on Suboxone.
Propranolol and clonidine.
Okay. All right. So you're gonna do the PHP. So you understand what I'm saying? Again, you're standing here before me, and had yesterday, while your wife was standing there, had I had all of the necessary information, because she kept telling me she didn't have her documentation, but you did not complete it. It says it right there, and then it says verify, which means that they called the coach, they called Izzy's house, and they verified that you did not successfully complete it. Walking out the front door when you have had enough is not completion. I don't see why there's this breakdown in communication with you and your wife. I don't understand it.
No, I apologize. It's just the way.
Well, Mr. Harris, I'm going to give you. Here's what we're going to do today. Like I said, you're going to do the PHP at the coach. You're going to remain on monitor. You're going to go back down to court services right now, and Officer Ruff's going to check with the coach and see when they have a bed available. But if I don't know, I'm going to have her reach out. It's very possible I could take you into custody yet today, because I don't believe you're being 100% truthful with me. You're certainly not being truthful with yourself. I'm trying to help you, but you need to just come clean, because you and your wife are on a course of destruction, and I'm trying to help you with it. The first thing that you need to do is be honest with yourself, and certainly be honest with me. And don't tell me that you're the kind of person that doesn't lie, because I think you're smart enough that. The other thing I want you to do is you're going to get your GED. You and your wife both, she claims that she doesn't have any education, no formal education whatsoever, none, right?
That's what she said. I disagree with.
You disagree with what she said?
Yeah.
Well, the report said she had a third grade education. She said, no, I never had any formal education. But she can read and write. Her signature was very nice. It was legible. All right, so you're going to get your GED. Looks like you have 21 days jail time credit. All right, Ms. Tranter, did I leave anything out for today?
I don't believe so, Judge.
All right, go back down to court services. Would you check it with the coach to see?
The only thing I'd like to point out on custody is he reports he's got a good job, and he was clean today, and I just ask the court to consider those things. So that's all.
We have verification of employment?
He's delivering, he bought a truck, he's able to get a Silverado, and he delivers appliances.
Is this under the table?
I got
Is this under the table? It's a yes or no question.
Cash?
Yeah.
Is cash?
I
All right.
got receipts for it, if that's what you mean. Like myself, self-employed.
Self-employed.
So this who do you deliver for?
That's a job that I have an interview for Friday.
All right, so, okay, let's do it my way. Go down to court services right now.
By the end of this hearing, the judge chooses not to immediately revoke Mr. Harrison's opportunity for intervention in lieu of conviction, but the warning could hardly be stronger. Instead of accepting Harrison's explanations at face value, the court orders him back into the recommended PHP treatment program, keeps him under supervision and monitoring, directs him to pursue his GED, and makes it clear that any further dishonesty or failure to comply could result in being taken into custody. Throughout the hearing, the judge repeatedly stresses that successful rehabilitation requires honesty, accountability, and following professional treatment recommendations, not personal preferences. Rather than focusing only on punishment, the court emphasizes giving the defendant one more structured opportunity while making the consequences unmistakably clear. If you found this case as intense as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more powerful courtroom breakdowns.